No mai, haere mai. Welcome to webinar number 2 for the Legislation Design Advisory Committee on chapters 1 and 2 of the legislation guidelines. I'm Guy Beatson. I'm currently General Manager at the Institute of Directors in charge of the Governance Leadership Centre and also the Deputy Chair of the Legislation Design and Advisory Committee. I've got with me 2 panel members today who we'll come back to shortly, but I'll get them to introduce themselves. I'll first turn over to Bridget MacArthur.
Kia ora koutou, called Bridget MacArthur, ahoa. I'm one of the non-public service members on LDAC, and previously I held the same role on the old LAC. In my day job, I'm a partner in the Wellington office of Greenwood Roach Project Lawyers. My background is over 30 years as a corporate commercial regulatory lawyer, spanning most sectors of the economy, but with a heavy focus on energy and resources and large industrials.
Cool, thanks Bridget. And our other panel member this afternoon is Carl Simpson. Do you want to introduce yourself, Carl?
Yeah, kia ora koutou, ko Carl Simpson aho kei te tari tohu parimata o e mahiana. I'm Carl Simpson. I'm Deputy Chief Parliamentary Council System and Stewardship at the Parliamentary Council Office. So that's about helping PCO achieve its objective of high quality law that's easy to find, use and understand. Also a member of LDAC and former chair.
Great, and it's really good to have some people with some really great experience, both from the non-public service side of things as well as the public service side of things. This webinar is going to be in 3 parts. Shortly, we're going to play a short presentation which outlines something about the Legislation Design Advisory Committee, how it operates and those sorts of things, as well as what the nature of today's webinar is about. We're then going to turn back to our panel members, Carl and Bridget, for a panel session with some questions and answers from me. And then about halfway through the hour we've got today, we're going to open up to you, the audience, for our webinar to ask questions of the panel. So without further ado, we'll share the presentation. Tēnā koutou katoa, no mai, haere mai. Welcome to the LDAC webinar series. Through this webinar, you will learn about chapters 1 and 2 of the guidelines. Before turning to our panel to answer some questions about this, we will provide a brief overview of LDAC and its role. The Legislation Design and Advisory Committee is made up of members appointed by the Attorney General to support good legislative design. It's a mixture of public service and non-public service members. All members are voluntary or unpaid for their LDAC work. In the case of the public sector employees, their time is loaned by their employer. PCO provides secretariat support, including advisors to support the committee. Members have a broad range of backgrounds. We draw members from legal and policy teams within departments and Crown entities, as well as academics, lawyers, barristers and consultants. A broad range of skills and experience is important because good legislative design is multidisciplinary. It's not just about the law. We have 3 functions. We publish and maintain the legislation guidelines and supplementary material. That's Government's Handbook for Good Legislative Design. The most recent edition was updated in 2021, but the guidelines have a decades-long history and are direct successors of the LAC guidelines. We carry out education and engagement activities, like this session today, but also by department and by issue. Both these activities extend our reach beyond our advice function. It's common to see submissions to select committees refer to the guidelines, and ministers are required to address consistency with the guidelines in cabinet papers for bills. Our advice function applies at 2 different stages. The bulk of our work is prior to introduction, when we advise departments that come to us. And we also make submissions to select committees. We aim to support good lawmaking. We are guided by the guidelines and supplementary material. The guidelines are not about policy. They are about expression of policy in law. This means you will not find us giving an opinion on policy. It's important to remember that the guidelines are just that, guidelines. These are not rules that must be followed. Our goal is to help ensure that conscious design choices are being made. Today, the focus of our webinar is on chapters 1 and 2 of the guidelines. We will start with what is good design and why it matters. We'll then turn to matters to think about before starting, like knowing your regulatory system and knowing your policy objective or purpose of the legislative change. And then we'll look at how to ensure the policy objective or purpose of the legislation is clearly defined. That gives you a bit of background about LDAC and a bit of background to today's webinar. So we're going to turn to the first of those questions that we mentioned in the presentation. So what is good legislative design and why does it matter? And we're going to turn to Carl, who has long experience in these issues, and get him to talk about the building blocks to think about in terms of achieving that objective. Over to you, Carl.
Thanks, guys. So I think probably the first thing to say is that there's a lot of really important information in Chapter 2, and I won't try and cover all of it. It's actually the part of the guidelines that's had most work since the Legislation Advisory Committee morphed into the Legislation Design and Advisory Committee. So the 2018 version of Chapter 2 is takes quite an expanded version of what was in there before. Takes you through why good design matters, and essentially this is about good design being critical to achieving your policy goal. It outlines 3 objectives for high quality law. Firstly, fit for purpose, and that means both legislating only when necessary, and that's a matter that we deal with quite a lot, and designing legislation to last. And so you should be looking at legislation that lasts not just for the conditions over the next 6 months or the next 2 to 3 years, but the next 30 years in most cases. Secondly, legislation should be designed to be constitutionally sound, and that includes consistency with fundamental values and principles and Te Waitangi. And then thirdly, the focus on accessibility. So that's the balance between both primary and secondary legislation, but also other things like principle and prescription, administrative decisions and guidance, essentially about how people know how to comply and how you build flexibility within the regime. But I'd like to focus on 3 other things that are necessary for good design and an approach that I take when I'm trying to design legislation. Firstly is to think upwards. So that's about knowing the regulatory system itself. That's a really big part of Chapter 2. What does the regulatory system that you're dealing with do at its core, and what are its components? So that's broader than the piece of legislation or the particular policy project or problem that you're trying to deal with. So think about whether the law is about allocation of rights or modifying behaviour or economic regulation or safety. And now there secondary objectives you need to build into the regime or to think about in the The second approach is to think across. So how do other regulatory systems deal with the same types of policy problems? Or how did other jurisdictions deal with the same issues? And so if I take an example, in health and safety at work, when we were revising the Health and Safety and Employment Act, the main place we looked at was the regime that had been recently developed in Australia. And we used that as a guide to compare what we had before and think about where we want to go in the future. And finally, don't be hesitant. So everyone in the process has something to add. The absolute worst thing you can do as a policy advisor or as a lawyer, or even as PCO, is to treat the job as done when Cabinet signs it off. Actually, that's just the start of the process. Legislation design is not solely the domain of any one person in that process. It's everyone's job, and everyone has something to contribute. So dig in, think about what the words mean. Don't just look at the queries. And I've said, and Guy said at the start, that this is an interdisciplinary job. It's a place where many eyes are needed. So, and actually, a really good example about why good design matters is actually covered in this week's capital letter. That's talking about the wetlands regulations. And according to the report, and I haven't got detailed knowledge of those regulations, but the responsible minister there is pointing to a flaw being in the regulations and noting that it's taken more than 18 months to fix. A different approach to design may have avoided the problem altogether. So that's just really just a thumbnail sketch of Chapter 2, but read Chapter 2, it's really important.
I think what you've done, Carl, is actually provide a bit more gloss in terms of what the guidelines are intended to do and a practitioner's view of that from the work you've done. And think, emphasize in all of that, the notion of actually seeing what you're doing in a legislative context, but also a policy context, And one of the things we'll come back to later in our Q&A is about the link to implementation. But if I can turn to Bridget, and almost from a non-public service practitioner's point of view, how can having a clear policy objective and purpose of proposed legislation help?
Well, Guy, the policy objective is absolutely critical. It should drive the design of the legislation and all the detailed decisions that are made when the drafting's being done. Our guidelines describe the policy objective as the backbone of the legislation, so everything else hangs off it effectively. And I think that's a really apt description. The policy objective should underpin what rules and building blocks you need, who or what is or isn't subject to the legislation, how you design the discretions, how you approach enforcement options, who any regulator needs to be, or does there need to be a new one. So you need to be very clear on what is the policy objective, what's it trying to achieve, who's going to be affected, and what are the regulatory bodies involved. Thinking of that backbone, what needs to hang off it to make this thing work. It's not necessary to determine every single detail of policy right at the outset, but it is desirable to settle as much detail as possible before issuing drafting instructions. And certainly, you don't want to leave important matters of policy to be settled later in regulations. The final thing I'd say, Guy, is that just having a clear policy objective isn't enough. As Carl alluded to, you need to ask, do we actually need legislation to achieve this? Legislation should only be made when it's necessary and is the most appropriate means of achieving the policy. For example, is there already a statute or common law even that deals with the point? Could the policy objective be achieved just as well through issuance of guidelines or directives or policy statements? So apart from unnecessary regulating and cluttering up the statute book, there's also a huge cost element involved, not just the cost of enactment of legislation, but also the downstream costs of compliance and enforcement and other indirect costs. I would point out that's actually a cabinet manual requirement, and there's a lot in the cabinet manual that actually crosses over with material that we cover in the guidelines.
That's really important, Bridget, and really thanks for that. And I think as you've talked through that, it occurs to me that what you've outlined also is a reason to have departments who have policy that needs to be translated into legislation, engage with the Legislation Design and Advisory Committee early, just to talk through some of those things and even to test whether that legislation is necessary. But one of the great things, as I was alluding to earlier, of having non-public service members on the committee is some practical experience. And I guess I'm interested to hear, how do you think having a clear purpose helps your clients in the real world or in practice?
Well, just before I answer that, I'd just note by way of context that many, not all, but many in the private business sector take a real interest in policy development. And those particularly well-informed know that the best time to try to get in and influence policy is at the time of formation, which of course is long before a bill is introduced. They're keen to contribute at the policy stage, to identify issues and unintended consequences, to influence how it shapes up so that it's workable when it's implemented. And of course, that's where good consultation comes in, and that's a whole separate topic in itself, and there's plenty on what is good consultation in the guidelines and elsewhere as well. So turning back to your specific question, I think there's a particularly good example of legislation that has a clear purpose statement, and that's the Overseas Investment Act 2005. The purpose statement, just to shorten it a bit, it is that the Act is all about acknowledging that it's a privilege for overseas persons to own or control sensitive New Zealand assets. And I'll tell you how that plays out in practice when you've got private sector trying to comply with the Act, and it certainly helps make our job as lawyers easier, is that from understanding that purpose statement, clients get a really good sense about that concept of privilege, and therefore they understand better how to navigate the intricacies of the Act, particularly when they approach the exercise initially thinking, this is just an annoying tick box exercise that we have to go through. So there you have a concrete example of a well-enunciated purpose with the detail hanging off it.
It's an interesting point in terms of the new role I have at the Governance Leadership Centre of the Institute of Directors. Is an interesting thing in there, and trying to get the director community and the governance community thinking beyond compliance and towards those benefits. And I think you've highlighted really nicely why the purpose pieces of this can actually help take us beyond that compliance mentality. I guess we might just turn back briefly to Carl, given his long policy experience, and get you to talk a bit about what you think we can do during a policy process to ensure the proposed legislation is appropriate.
So it's thanks for saying how long-standing that is, guys. So it's coming up almost to 20 years in policy and legal roles for me now. But I remember very early on in my public service career, I was told that the rule about consultation is consult early and often. But I'd probably add a couple of caveats to that now, which is that you don't consult so often as to result in engagement fatigue. Because if you go along to people and say, I'm consulting you about the same issue again, people tend to give up after a while. The other thing is that having a mixture of formal and informal engagements is really useful to help shape your ideas, and also be going beyond just industry groups or representative groups to talk to people who actually do have to engage with the regime. The other thing is that Māori rights and interests need to be identified and considered early, and there's actually there is a growing realisation, and we see this much more, that those matters do touch on many more projects than used to be considered to be the case. You need to build engagement early enough to make sure that you're able to respond appropriately to those matters. So good design also requires engagement with other agencies, particularly the regulator, if there is one, and understanding how the regulator in your system operates, and if and how they'll need to change is important. That's also why we have advised and has been followed to set up the regulator first in significant reform. So you'll see a consistent theme from that in things like financial markets, health and safety, fresh water and housing. In those circumstances, the regulator has been set up for the regime, and then the regime has been built around the regulator when there's fairly significant reform. But it's also important, if you're changing the role of the regulator or adding a new function, to understand, I mean, do they have the capability at the moment to be able to perform that function, and what will they need to be able to do that? The other thing is to be really open-minded about what the stakeholders are really saying, not just necessarily what they put in paper, but what's underlying that, and whether or not there's something that you can learn from what they've provided to you or said to you that you can use to go back to what I was saying before about understanding how the regime works. So just an example of that, I was working on what was then called the Securities Law Review, and one of the stakeholders, who I won't name, said that we don't need securities law at all, and that we should just abolish the Securities Act and the Securities Markets Act and rely entirely on the Fair Trading Act. Now, that's not the direction that we went. But in terms of the policy approach, it was a bit of a light bulb moment. The idea was actually at its core, financial markets was about conduct and about regulating conduct of people. There's some additional things about governance, about disclosure on top of that, but at its heart, it's conduct. So the consequence of that is, we talk about the Financial Markets Conduct Act, and we have part 2 of that act is a replica, or at least a reflection of the Fair Trading Act principles. So that submission that we got helped us to understand what the core of the regime was about.
Yeah, no, that's really helpful. And I guess this reminds me of my own experience somewhat earlier in my career with working with a bunch of regulatory policy people who saw consultation, I think, as just another tick box. And I think your example and some of the rest of the conversation we've had around this topic this afternoon highlights the fact that actually it's more than that. There's a lot of wisdom in those stakeholders, particularly when it's something as important as legislation and the policy that goes with it. But also that whole notion of actually being open-minded to the fact that it might be something you've missed or some way you haven't understood it. And I guess the second revelation out of what you've said is the notion of actually having somewhere to structure and put the feedback you're getting. So actually having a decent framework that links back to these purpose ideas is pretty important. Before I go on, I should note that for those participants who haven't yet seen it, there's a Q&A button at the bottom of the screen. And if there's questions that come up as we go through this first panel part of the webinar, feel free to put those questions in there. A couple of you have already, and we welcome those, and we'll move to those in the second half hour of the webinar. So we're now going to talk about purpose clauses and how they can be used to support the design of legislation. So I'm going to turn back to Bridget now, and we're going to talk about some of the reasons that a purpose clause might be used. So what sort of circumstances might they be used in, Bridget?
Yeah, so a purpose clause enunciates the policy of the legislation, basically, and they can be used for a range of reasons. These reasons aren't mutually exclusive. Not all will apply all the time. Bear in mind also that you don't always need a purpose clause. Only use one if there's good reason for it. So some of the reasons to include a purpose clause could be, first of all, communications reasons. And that is, you're trying to make the basic purpose of the legislation or regime clear to the reader before they get into the detailed provisions. Secondly, there could be signalling reasons. In other words, to set the direction of the regime, often to signal a change in high-level policy. Thirdly, there could be concrete administrative or legal reasons. And this would be either to set the basis for implementing, monitoring, and assessing performance of the regime at a later date, or at a more micro level, to set the basis for statutory criteria to be applied or tests to be applied in exercising discretions under the regime. And thirdly, there are often just interpretative reasons where the purpose is plainly just to guide the interpretation of the legislation. There's a different type of purpose clause that we occasionally see, and I know that Carl has previously expressed some misgivings about this sort of approach, but sometimes in regulated industries, we see a type of purpose clause that actually isn't stated to be a purpose of the Act, but is stated to be a purpose or objective or set of objectives of the industry regulator. And examples of this can be found in Section 43ZN of the Gas Act 92, and also in Section 15 of the Electricity Industry Act 2010. So they are expressed as specific objectives in one part of the legislation, which is in those cases all to do with governance of the industry, and they're expressed in addition to the general purpose of the Act, which is sort of basically about having an efficient and smooth running industry. Lastly, you need to be careful about purpose clauses, and we'll talk about some of the limitations later in this session.
It's interesting, isn't it? I mean, the interesting thing, as I mentioned before, having non-public service members on the committee who actually do real work, as opposed to thinking more broadly in terms of sort of these conceptual policy issues and design issues, is you can bring some real world stories to the table. So I'm interested how, where you've got examples of having seen some of the stuff you just talked about in working in practice.
Well, I've actually got a really good one in the gas industry, and this is from work I've done, but it's all out there in the public domain and published on websites, so I think I can mention it. I mentioned before Section 43ZN of the Gas Act, and that's located in the part of the Act that deals with governance of the gas industry. And that section says that the objectives of the industry body, which is the gas industry company, actually a co-regulatory body, its objectives in recommending regulations to the minister are, and they set them out, so the principal objective is to ensure that gas is delivered in a safe, efficient and reliable manner. And then the Act goes on to give it some other objectives, and they're a whole list of things, but just to paraphrase them, they're about promoting the ongoing supply of gas to meet energy needs, minimizing barriers to competition, providing incentives for ongoing infrastructure investment in gas, and exercising sustained downward pressure on costs and prices. Now, it's apparent from reports published on Gas Industry Company's website that in its work, GIC, through its management and board, is constantly looking back to those statutory objectives in undertaking its co-regulatory function. So, for example, when it had to sign off on a proposed new gas transmission open access code a year or two ago, actually it might have been 3 years ago, I'm starting to show how old I'm getting there, it very much analysed the detail of that code, each bit of that detail by reference back to those objectives.
It's really interesting that that's in a co-regulatory context too. So the notion of actually having almost a clarity of purpose that the participants in that co-regulatory arrangement can refer back to makes a huge amount of difference. It's a really good example. So thanks for that, Bridget. I thought we might just turn back to Carl, because one of the questions we get in various of the LDAC subcommittees working with departments on prospective legislation and bills is about, well, how the heck do we do this? And more particularly, when should we do it? So when should these purpose clauses and arguably principles as well be developed in the process?
So I start thinking about them when we're developing the policy, the start of the policy process, because the initial cabinet paper or discussion paper you're drafting should be talking about what the purpose of the regime is. And the ideal is to continue to refine that through the process and turn it into something a little bit more legislatively or legislation-y a bit later on in the process. And just going back to Bridget's comment about the objective things, this is really important about how things like purposes and principles and objectives all fit together. It doesn't really matter necessarily whether you use the terms purpose, principle or objectives. What matters is that you've got a good theory about how they all fit together, and you've actually thought about how the purpose of the Act and the principles, if you do have principles, or the objective of the regulator fits together. The other thing that I'd say is that it does take a lot of time to get them right, because they do have legislative effect. They don't operate on their own. And so as you're developing up the substantive parts of the regime, you need to check and recheck against what that purpose is doing and whether or not it really reflects what the rest of the regime is doing. And finally on that, I mean, when you get submissions on them, really closely look at them and think about, is that what we're intending, or is there an interaction here that we're missing? And, be prepared for esoteric conversations about words like provide for and ensure and take into account, or any number of other verbs that you could possibly use, and then playing with those and rechecking.
It's interesting, isn't it? There's quite an important thing in terms of the theory piece of that, the theory of the policy, but also in some senses the theory or the concept of the legislation itself, partly so that people can understand it. But it occurs to me that it's also pretty important in terms of regulatory evaluation, of which, and where there's not that much of that, but to the extent there is, that provides a good foundation for that too. It's fair to say, though, that as we move to the last segment of the Q&A with the panel, not all purpose clauses are created equal. They should be developed early in the way that you've talked about, and they need to be checked and rechecked. But there's also a bunch of limitations. Certainly in my work from various of my past lives, the notion of purpose clauses having some sort of high place, kind of sitting next to the Bible in some cases, is a bit of an interesting thing. But there are limitations, and we're going to pick into the sorts of what types of clauses there are, but also the limitations of those clauses. So I'll go back to Carl. So what are some examples of the clauses that we see? And I see that's one of the questions that's cropped up in the Q&A already. So maybe we can deal with that here too.
So we do see a range from no purpose clause at all, and we'll talk a little bit about that later. But we see purpose clauses that are really describing the legal means or effect of the bill. It's a little bit like what the long title used to do in most cases. So these are probably the lowest risk, but also lowest reward approach to writing a purpose clause. So they're essentially an outline. So you could have something like an act to facilitate the use of permitted documents in the proceedings of courts and tribunals. So that's, that tells you what the act is for, but it doesn't tell you how it is intended to do. And we also see use of policy, purposes, and principle clauses fitting together. And probably the best version of that we deal with every day is sections 4 and 5 of the Official Information Act. So that talks about the key purpose is progressive openness of availability of official information, and then the availability principle guides every decision within that regime. So that's you can see quite a clear differentiation between what the purpose is doing and what the principle is doing there, and I think they work really well together. We also see structured purposes clauses. So the Financial Markets Conduct Act and the Civil Aviation Bill has, and a number of other regimes have these now. So you have sort of a list of, or a very short main purpose, and then a slightly expanded list of additional purposes. So that's designed to say, this is what the Act is mainly about, and here are the subordinate or the secondary objectives that the Act is dealing with. So it's really important, though, that these are a succinct reflection of the policy. They need to be succinct enough or specific enough to be used in corporate documents, or as criteria for decision-making, or as a guide for interpretation. And all of those approaches are legitimate. And it's not always the right thing to spend a lot of time working on your main and your additional purposes, particularly for things like amendment bills. It would add confusion to have a purpose clause in an amendment bill. And you have to be really careful when you're playing around with an existing regime as well. If you're amending the purpose of an existing act, there's a really high risk of unintended consequences, both by grafting a purpose onto an existing act or making substantial amendments to those. So that's a place to be a bit more conservative.
Yeah, it's a pretty important health warning in the midst of all of this, isn't it? I mean, we've talked quite a lot about the benefits of having these purpose clauses. There's clearly downsides, and particularly with that existing law, but there are a number of other limitations and limits for these types of clauses, both purposes and principles. I wonder, Bridget, if you want to just outline what you think the limits for these types of clauses are.
Sure. Before I do that, Guy, we should just flag that LDAC has published supplementary materials on purpose provisions and statements of principle, and they're on our website, and they go into more depth than I will here, so I'd urge people to consult them. So some of the limitations with purpose clauses. First of all, if you're going to have a purpose clause that's intended to relate to the whole Act, you need to make sure that it does actually cover the ambit of the whole Act. And conversely, you need to make sure that all provisions in that Act should somehow be able to be tied back to that stated purpose or purposes. It can be quite useful to have purposes within different parts of an Act. For example, those Gas and Electricity Act examples that I gave earlier. You just have to watch out there that you consider carefully the relationship between those purposes within a part of the Act and the main purpose of the Act, so that you don't end up overcomplicating things. You need to be careful with a purpose clause not to overpromise on what the substantive provisions actually deliver. Avoid long lists of ideas that are potentially conflicting. A whole bunch of different considerations and objectives can be really difficult to interpret. and they can cause difficulties down the track in implementing and operationalizing the legislation. Check and recheck the purpose clause to make sure throughout the legislative process that it remains fit for purpose, as Carl mentioned earlier. And finally, beware of retrofitting or amending purpose clauses. As Carl said, that can be a really difficult fit to achieve. So in terms of statements of principle, statements of principle are like high-level policy clauses. They set out the underlying aims and values. They should guide and limit the exercise of powers and duties. And they need to be really clear about how they relate to the rest of the legislation. So who has to observe them or be guided by them? When, in what context, and doing what? What weight do they have? Is there a balancing act that needs to be carried out of any sort? It's also important that principles enhance decision-making processes rather than confuse it. You don't want them to create complexity and risks for decision makers under legislation. So some guidance on statements of principle. I'd say make sure they align clearly with the policy objective, ensure there aren't too many to be taken into account that in a way that will result in something that's unworkable and complex. The order in which the principles are stated usually doesn't signal any particular hierarchy or weighting, but have a think about whether some should be ranked ahead of others. Consider the consistency of those principles with purpose clauses and with other statements of principle carefully. Also consider whether decision makers will balance the principles or will be permitted to give some more weight than others. Just like with purpose provisions, be careful about using really broad statements of principle, especially if they create some sort of unquantified statutory obligation. They may in fact go further than the substantive provisions are intended to do. Finally, sometimes if you do have a broad statement of principle, it can be helpful for it to be qualified. For example, and there's a number of turns of phrase that are used here throughout the statute book, but you might find that the decision maker has to take something into account, but only as appropriate, or has to do something, but only having regard to the resources available. There's a range of those sorts of qualifiers that we find.
Yeah, it's useful to see the limitations here, isn't it? And so it's all very well to talk about the benefits. That guidance you've just outlined, Bridget, I think is really helpful, and I think it's helpful from the perspective of, I guess, my own sense of legislation, which is mostly about the notion of getting as close as we can to having a manual, a way of kind of supporting particularly regulators to be guided by the way the legislation works. And so the notion of thinking about and being mindful of the people who have to implement this legislation and the people who have to interpret it, particularly around those purposes and principles, is pretty important. And I guess there's a question for our webinar audience today and others who come to the Legislation Design Advisory Committee is to think about how a regulator or court's actually going to grapple with those lists of principles, particularly with the limitations that Bridget's talked about. How are they actually going to make a decision on the basis of this? How are they going to weigh the things in those lists or weigh a decision on the basis of purposes? So I think that largely concludes our panel discussion. I